You are listening to the Aging Starts Now podcast, where it's all about responding with confidence to the legal, financial, and personal challenges created by a disability, unexpected illness, or aging in general. Join us weekly as elder law attorneys Barbara McGinnis and Chris Johnson, along with other members of the Johnson McGinnis Elder Care Law and Estate Planning team, talk about the tools, techniques, strategies, and services that will make the elder care journey easier for everyone involved. Get ready, because aging starts now.
Do you have a family? If the answer is yes, then you need estate planning documents. I'm Outreach Coordinator Dana Hentschel, and today I'm talking with partner and certified elder law attorney Barbara McGinnis about some recent calls to our office that perfectly demonstrate why everyone needs a proper estate plan. Welcome, Barbara.
Morning, Dana.
So we've been chatting lately because I don't know what's in the air, but we've had a string of calls from people who just don't have documents in place. So like yesterday, someone called our office, a wife whose husband had an incident which caused him to be in a coma. And there were no documents in place. The wife didn't even know what accounts they had. And I mean, sometimes this is common, I guess, like I do all of the bills in my household, and I'm sure that there's always a spouse that kind of takes the lead on that. But because there are no documents, can you kind of share with our listeners what the wife is now facing now that her husband's in a coma?
Oh my God, can you imagine how lost she probably feels right now? I mean, not only is this person that she loves and care about in a dire medical situation, but she's just left sort of floating out there about the financial aspect of their life. So I can't imagine how scary that must feel to her. The safety net process for this situation, and it's going to help with legal authority, is called a conservatorship. So obviously the husband no longer is able to designate a decision maker. And it's going to have to be something appointed through the courts. And I call that our safety net, so that there is a mechanism that we can get her legal authority. When I say we, I kind of mean the big, broad legal community, because, you know, we don't do conservatorship work, but there's plenty of attorneys that do. And so you would go to the county of your residence. That's where the petition for conservatorship would be filed. There is a process for granting emergency authority. So in urgent situations, I'm certain the hospital is deferring to her as the next of kin in making medical decisions. There is a set of laws that help with that on a temporary basis, but all of the things that she probably has to do, pay bills, making sure bills are getting paid, where's our money, you know, that's going to come under the conservatorship process. And all that's going to do is give her legal authority. And then she can start looking for that sort of information that she might need, whether it's getting into his email accounts to see what's being emailed, or online banking, you know, searching history browsers on a computer, or just monitoring the mail to see what comes in. But mail at my house is mostly just junk mail. Everything real and important seems to come to me online in one format or another. So that's what she's now facing. So it's a tragedy. And it's this not only medical emergency, but she's got a legal emergency, and it's just leaving her foundering. So it could have been.
I think a lot of people assume I have been the spouse for 35 years. It should just automatically default to me, the decision making. You know, I can tell them that my husband's in a coma, and I can go to the bank and say, I'm the wife.
I'm pretty sure that the court would assume that she is the best person suited to do that, but it doesn't happen automatically. Now, if you have joint bank accounts, she still would have access to those bank accounts, But that's assuming that she knows what bank, what financial institution, who's their financial advisor, does she know who her accountants are? How do you even go about putting that information in place? So obviously it wouldn't make the medical event any easier for her, but the other stress of just dealing with the adult business could have been easier had there been powers of attorney in place, both medical and durable general, and then her legal authority would be established. And at least if you don't want to be the one to do the bills and be involved in investment management, I get that. That's fine. And like you said, a lot of couples delegate those authorities to one person or the other. But having some general awareness of where our money is, who our financial advisors are, where does income come in? Where do bills get paid? What's automatic versus what do I have to schedule? And those kind of things. Having some general awareness is very practical to have, because you never know when there could be this emergency that you need somebody to step in for you.
Right. So now she, instead of just kind of using the paperwork that's there, she's got to call an attorney to get a conservatorship and have that lag in time and that expense.
Exactly. So, I would say we're talking a few $1,000s and then the court process. And it's just, I'm glad it's there as a safety net for these kind of things, but it's an aggravation that could have been avoided.
Mm-hmm. So, if you think a power of attorney is expensive, it's a lot cheaper than a conservatorship.
Absolutely.
And then also, I think with the power of attorney, you can do the business of that person. With a conservatorship, you do have to do their accountings to the court.
Yes, depending on the asset profile, once that's discovered, it sounds like in this particular situation, it sounds like she would be going with unknown assets at this time, needs the authority to start discovering that. Then she'll have to do a follow-up with the court for a property management plan, accountings, inventory and accountings, and then those go on annually after that. So it's an ongoing process as long as the person is alive. And then the probate court is the one that at his passing will close the conservatorship.
Okay. So I assume there was not a will in this instance as well. So then she will, after he passes, she'll have to hire a probate attorney, and then the state of Tennessee has a will set up. Is that right?
Well, so it depends. Once she discovers how assets are titled, if they are joint owners on the house and on bank accounts, then that asset belongs to the co-owner, the joint owner. But if there were assets in the husband's name only, without a beneficiary designation, those assets are subject to the probate court. And the law of intestate succession is what we refer to as the state's plan for you. If you don't make a plan for yourself, the state has a plan for you. And those are intestate succession. Intestate just means that you're dying without a will, and succession is sort of self-evident that it's what's going to happen next. So what happens next, if she is the spouse and there are no children, then any individual accounts from the decedent passes to the spouse. But if there are children, it passes by a percentage to the spouse and to the children, with the spouse not receiving less than a third. And then it kind of goes from there. So, there is a plan. for how the money would go. A lot of times, couples that I meet with, their plan almost always, and it's not right or wrong, it's just almost always the case, they want to leave all to each other and then to their children in equal shares. Probably only in blended families do I commonly see a portion to the surviving spouse and a portion to the children as their plan of choice.
Right. Well, we had another caller whose husband was in the beginning stages of dementia, and he too had always kind of made the household decisions. However, with this dementia diagnosis, the wife had noticed that he was kind of making some bad financial decisions and some bad investments. And she's afraid that his worsening, that this condition is only going to worsen. And she is afraid she's going to end up one morning broke because of his dealings. And so she was curious if there was a way to kind of step in and intercept some of these things. So they did not have durable power of attorney documents, though she thought he might sign them. But that's kind of a tough situation as well. Can you talk about some of her options?
Yeah, this one is just as hard, but in a different sort of way, right? Because again, dealing with the decline of someone that you care about and love, but you're watching it sort of slowly burn and get out of control. A power of attorney may not be sufficient in this situation. However, if you know if you have a relationship with your bank and you are joint owners on bank accounts, if you have a financial advisor or someone that is helping you manage your money, and you can share with them what's going on clinically and have a power of attorney, share that clinical information, and maybe a trust would help, that you move money into a trust, so and that the person with dementia not be the trustee. That might help sort of create a barrier between that individual and assets in making bad decisions that would be squandered. Adults are allowed to make bad choices, but when we're making bad choices because we are clinically impaired from an underlying diagnosis, we need to step in and help protect that person. So you might find some help in a trust, but if that person's not agreeing, then we need, once again, the heavy hand of the court. And so in this instance, it may not just be a safety net, the conservatorship process. It might actually be the ticket, because the difference between legal authority under a power of attorney, which is granted and shared between the principal and the agent, the legal authority under a conservatorship is legal rights removed from the ward and given to the conservator. So that person no longer has the rights over their money or the rights to make these bad investments. They would be protected in that instance, and give those to the spouse or whoever is the best person to act for the ward.
So in the instance of a conservatorship, if somebody called and tried to get his bank accounts or $10,000 for, I don't know, the latest scam, the person wouldn't have access to those funds because conservatorship would have been in place. Whereas with the power of attorney, even if you've kind of talked to your bank and said, look, this is happening, that person still has rights to access that.
That's exactly right.
Okay.
So, a power of attorney is a great tool for someone who needs assistance or wants assistance and they're willing to work with their named agent, it is doesn't diminish their rights as a person in any kind of way. It is durable through incapacity, not through death. So it would be durable even through a coma situation. But if the principal still wanted to squander money, quote unquote, still wanted, was making bad decisions that, of course, they don't think are bad decisions, they still have the right to do that. So it's not going to be protective in that instance, whereas part of the protection under the conservatorship is not just that the authority lies with a person that does have capacity and does know and have fiduciary responsibility to their ward, but there's accountability to the court. And a lot of times there must be permissions from the court. So can be protective for folks with mental health disorders, or in this case, a dementia that's just causing some severe executive function impairment.
Right. Well, of course, we've talked a lot today about power of attorney paperwork and the importance of that. I want to kind of touch on a will and proper estate planning, and maybe revisit a scenario that we may have mentioned on another podcast. But this is where a parent deeded their home to their caregiver child. I believe the parent was sick and the child was the caregiver, good kid, and it was going to be theirs anyway. So why not deed the house over? And then the caregiver child passed away before the parent did, and the caregiver child did not have an estate plan in place.
I remember that situation. Again, it's unpredicted, perhaps. Attorneys sometimes have the job of explaining to folks unpredicted things can happen. Just because it was unlikely for the child to die before their elderly parent doesn't mean it couldn't happen, and a backup plan needs to take place. So in that particular situation, the parent retained a life estate, so they still had a home to live in even after their child passed away. But that remainder interest passes through that person's estate plan. And in the absence of an estate plan, what do we know? The state has a plan for your estate. And this was an unmarried person with a legal child. And so interest went 100% to the legal child. Certainly not the desired outcome for anyone in this scenario. It was problematic and could have been avoided with some better planning. A couple of options for better planning would have been, if we really wanted to do the life estate transaction, make sure that all parties involved had testamentary instruments that would direct the property in a better manner. And the alternative that may have been one of might be a trust. And trusts are some of my favorite tools to help families meet their goals of asset ownership. So there could have been a better way.
Right. And I think something to mention, that the child of the caregiver child was underage, significantly underage, which meant that child's guardian kind of was the manager, and that child's guardian was the ex-spouse. And so I'm sure that was just made a bad situation worse.
Yeah, I'm sure there's lots of difficulty with family dynamics there.
Yeah. So, well, is there anything else that you would like to add, Barbara, as a cautionary tale?
Just that, we just point out these cautionary tales and use them as examples of how people find themselves in difficult situations that they certainly didn't intend to happen and did not imagine could happen to them. So learn from that and consult with an estate planning attorney or an elder law attorney to make sure that your documents were going to meet your goals. And it's easier to plan than it is to try to correct these situations.
That's right. Well, that is all the time that we have for today. If you have been begging your spouse or your parents or your best friend to get their affairs in order, please send them this episode as a nudge to get their documents done ASAP and stop putting it off. Johnson McGinnis Elder Care Law and Estate Planning is a life care planning law firm helping families navigate the healthcare questions and financial concerns that come with aging. Join us next week for another episode of Aging Starts Now.
Thank you for listening to the Aging Starts Now podcast. For more information about today's show, visit tn-elderlaw.com, click on the Free Resources tab, and then click on Aging Starts Now. You'll find the show notes there. And while you're at it, why not check out all the free resources available at tn-elderlaw.com? Document downloads, the Johnson McGinnis blog, educational videos, informative articles, helpful links, a TV show, and more. It's all there, free for the taking. If you enjoy listening to the Aging Starts Now podcast, please subscribe, rate the show, or leave us a review. It's easy to do on whatever app you use to listen. We would love your feedback on the show. Aging Starts Now. We'll be back next week with more candid discussions about the challenges created by aging, disability, and unexpected illness.